Bam! Welcome to the live stream tonight. Pro Se Legal School. Yeah, the website's the Lawsuit Center. This part of it is the legal school. And in the legal school, we expect you guys to, to do some homework all the time because everything's changing and we don't have all the answers. We're just learning them. Oh, sorry. Welcome. I'm Coach Neighbors. Okay, let's skip that crap and get right to. Okay, we're going to watch video first, give a few people a chance to get here before we start rolling with what we're going to be talking about tonight. The Rule 12B workshop that we had, a lot of people, there was a lot of value in that. And so that's what we're going to share tonight. Well, maybe. Welcome to Pro Se Lawsuit Center. I'm Coach Neighbor. Today we're putting together this little workshop video for the workshop. Failure to state a claim is a bar member trap. Failure to state a claim is a bar member trap. So welcome to our workshop tonight, and we're going to be talking about that. Tonight we're going to learn about one of the most misused defenses in civil litigation, and we're going to learn how to stop one of the most used bar members' tricks to dismiss your case. We're going to, my grandma said, two birds in the hand is worth one in the bush. Two birds in the bush, two hands in a bird bush. Okay, we'll work on that later. Okay, so remember, tonight you're going to learn how to stop one of the most used bar member tricks to dismiss your case. The Rule 12B failure to state a claim workshop. That's what we got going on tonight. Now, you think they defended the case? They didn't. They used a phrase with no facts behind it. This workshop training is going to show you how to identify it and respond to the Rule 12B dismissal. That's what we learned. That's what's going down tonight. I'm working, Lily. You can come in. Come in and get up here if you want to. We get a little rowdy sometimes. She's still kind of good. Okay. I'm working now. I'm dressed up, so don't worry about no rowdy, nobody up in here getting jacked up, because we ain't have no problem when we're looking good. Okay? All right. You sit down over there and let me do my work over here so I don't have to, get rowdy with you. Sit down over there and chill. Thank you. No phrase, no facts, no facts behind it. This workshop training shows you how to identify that and respond to the Rule 12B dismissal. And we're also going to provide you the structure that we use to build the document and a copy of the document. And if I remember, I said that we'd be offering, the credit card package to the first 5 people. And then if anybody else is interested in that wasn't in the first 5, then you would have to just hit me up when I'll send you the Cash App link, and let me know what you need, and I'll email it over to you. Civil litigation is built on precise procedural rules. When those rules are misunderstood or misused, it creates confusion for litigants, and the court exploits that confusion in the interest of assisting fellow bar members crush you in their administrative process. Chat would wanted to clean that up. No, we keeping it real. Real 100, 24/7, 24/79. Okay, we ain't trying to roll like everybody else, all right? Failure to state a claim is not an affirmative defense. Tonight, we're going to learn how to make the document you need to stop that fraudulent attempt to avoid your civil liability. A true affirmative defense must introduce new factual matter that defeats a claim, even if the allegations in the complaint are assumed to be true. Tonight, we're going to learn how to make that document you need to stop this attempt of them throwing, they start making you jump through hoops and then hoop your ass right out the back door. Not anymore. Nope, we ain't going out the back door. We don't like the back door. What we're going to be studying tonight is a specific legal point that gets twisted up a lot. And, y'all know I play football, I box, and I did all this crazy stuff. And those are things not smart people do. So I like to keep this shit simple so I can understand it without a bunch of questions. I shouldn't need questions. I went to school for a few days. Stay with me. Failure to state a claim is not a proper affirmative defense. Here's why. It's not actually a defense. An affirmative defense is supposed to introduce new facts that defeat the claim, even if the claim is true. Like, let's say. Now, I'm going to say these here, but y'all know if you're in my program, there's a few of these that ain't going to work. That ain't going to help them. Okay, but for the sake of this conversation, Coach, we're just going to keep it simple. Okay, so a few examples that they come up with are statute of limitations. Well, we roll with fraudulent concealment, bam, so we ain't worried about statute of limitations. Arrest judicata. Well, they want to say, and then estoppel, they want to say that they can't. You can't go after them for the same thing, whatever. Well, wait a minute. Fraudulent concealment, bam, bam, crushes both of those. Oh, it's getting a little hot in here, but not for me. So the first one is statute of limitations that is a real affirmative defense. It ain't here because when you roll with fraudulent concealment, that's done. There ain't no statute. There ain't no limitations. There ain't the limitation is told. Then, you got arrest judicata waiver. Well, you can't waive constitutional rights anyway. So we ain't even going to spend an estoppel. Both of those are right in. So the only one we got left, okay, in my head for affirmative defense of anything you get from winningcourtnow.com, I'm saying only two, and that's payment and release. No, I'm talking about them paying us and releasing us. Well, okay, they got it twisted. So why the hell can't I twist them? Twist them. Okay, sorry, I got a little twisted. I don't. I get that way when I'm reading their stuff, but we gotta have it because when y'all go and research, y'all pull up this same stupid shit. Well, all of mine ain't stupid because I got two in here. Okay, so actually, there's only one. Okay, the payment, okay, that ain't no affirmative defense because the payment was generated with your own damn signature when you signed the stinking thing that they, remember how that worked? You sat down, you signed that thing, and then you was the only one that signed it. The bank didn't sign. Nobody from the bank signed. Oh, wait, they did sign it later after you left the table. They stamped, paid to the order of honor, and turned it into into some funky thing. Okay, sorry. Security. I know the words. Okay, that's what it turned into. And the processor through the Federal Reserve for Electronic Credit. Now, Modern Money Mechanics is a publication put out by some dudes. I'm gonna call them white dudes. No offense to anybody. that ain't that ain't white. I mean that. Okay, sorry. Okay, but I mean, if you read the book, okay, man, is okay. But anyway, so I'm just gonna have to say that the payment ain't working for me either. That's not affirmative defense because they can't prove there was a loan given to you. They can't prove that lad's loan, mortgage loan, wasn't generated with your signature. They can't prove that it wasn't. They can't prove. They can't prove. And you know what else? They can't prove that they did not commit real estate deed fraud when they registered your shit in their office. Their law says they're supposed to deliver that shit to your house, and it's not conveyed. Yada yada yada. But they did their constructive delivery, and then they registered. They registered your property. I used to think they registered for the sole purpose of just to start the property tax. I have videos where I actually said that. And then I got to looking more inside. And well, then it found out that no, it wasn't registered for the sole purpose of the property tax. Your deed was registered in their office to allow the first illegal lien to be put on your property. That's how I got it. That's how I got it in my head. Now work with me here. I know y'all think I'm crazy. People told me I'm crazy. They sent me back for crazy, man. In case I'm crazy because I'm crazy as right. Okay, but here you go. Think of it this way. If there were several people who own property, all of those people have to be present to sign that to sign that, right? And there was nobody there except you. So if the fact they accepted your signature, the alleged lender, there wasn't no lender, okay? It was just a bunch of bar members, and RICO co-conspirators. Okay, so no, there was no lender, They told you it was going to be a lender. You sat down and signed. And then the fact they accepted your signature on the lien and there was nobody else to sign, keep that in mind, proves that you own the property already and I smell stink. No. And then they did their constructive delivery where they registered in their office. Now, I know what you're thinking, what's constructive mean? That means that they're not going to talk about nothing about your property before it was registered. All of that shit is shung the hell up. Ain't nobody trying to talk about that. Well, come on. Okay, all right. Before your property was registered and reclassified as agricultural, residential, or commercial, and residential is actually a government official property. You won't get that shit up. You ain't going to find it on the first page. Okay, before it was your private property. It was your private property before that. But the problem is, one, the Constitution says that, and not once, but in two different places, that private property is not to be taxed. Okay. So, but that's not the reason why they registered. Once they registered, they allowed them to put the fake mortgage lien on your shit. Now, I know I'm talking crazy. All right. But if you stop, move all the bullshit aside, then they accepted your signature on there. All of our debts supposed to be paid back when it took gold and silver or whatever. And that's like 200 more videos of some complicated shit that nobody knows. I don't like to do that complicated shit. If they accepted your signature on the damn lien, then you own the property or something. And then they process it through the Federal Reserve for electronic credit. Now, Modern Money Mechanics said they got 9 times the amount. Now, Dr. Arthur, a friend of mine who buys these things, these notes and things before they get to that whatever, says they get 22 times. I can't do the math on all that. And then they take it back and then they sell it again, and then I'm getting dizzy. So the only one of these that could be affirmative defense in my head is a release. The property already. Okay, sorry. I'm still on the wrong side. On the wrong side of the fence. No, the release adds new information, and none of the others They just kind of jacked up my presentation here. I gotta check myself down. But that's all right, because we keeping it real. We keeping it real, and I don't have a problem being wrong. I don't. I do not have a problem being wrong, because if I am, I'm about to learn some shit. So failure to state a claim does not add any fact. It just argues the complaint is legally insufficient. Because of that, I'm going to say it's not. I'm supposed to, no, it ain't. It's not. It's a motion, not a defense. The proper place to raise it through a motion to dismiss under Rule 12b-6. That's how that's supposed to work. But not as a one line inside the answer to get your shit thrown out. If the defendant has already filed an answer, the proper vehicle becomes a Rule 12c motion for judgment on the pleading. Courts frequently strike Rule 12b as an answer because it is a legal conclusion. It is redundant, and it's not a true affirmative defense. It doesn't add any facts to the table that trump everything. Courts often say something like the failure to state claim is not a proper affirmative defense because it merely asserts a defect in the plaintiff's prima facie case. Lawyers include it out of habit to preserve the issue. They actually include it out of habit to throw your shit out if you're because they ain't got time to deal with you. They got so many people over here scared and kissing their butt and not standing up. They ain't got time to deal with those guys. And all the bar members are bored on it. They can do that, get it thrown out real quick, hop on down the street. They're not used to people doing the homework, and they're not used to people having the resources they have now today. They're not used to having crazy ass people that make it their life mission. And then there's the other people that don't make it their life mission. They do it because it's their therapy. It's their therapy. Helps them get it done 24/7. It helps them remember what you get cuando tiene miedo a esto. Un crajete, but not para critico. It's not for credit. Actually, it is, but it's not for you. They get the money. Okay, sorry. We're gonna make another video. Yeah, but technically speaking, many courts recognize it as improper boilerplate. That's what they say when you're researching this. Many courts throw your shit out when you do that if you don't understand what the hell is going on. If you don't understand, the key thing is that failure to state a claim attacks the plaintiff's pleading not through new facts when someone uses failure to state a claim as a defense, but in our non-conventional program, no, only one of those is the last one. None of those is going to help them get by the fire that you're going to be bringing to the table when you get done hanging out at winningcourtnow.com. Now, failure to state a claim does not add any facts. It only argues that the plaintiff has not proven their case. Because of that, courts may say it's not actually a affirmative defense at all. And courts often use this defense. This is brought through motion. Because those procedures already exist, adding it as an affirmative defense does nothing new. It is a legal conclusion, not a factual defense. When lawyers write it in as their answer, the plaintiffs fail to state a claim. That statement contains no facts. Consider it to be legal conclusion. It does not provide notice. Affirmative defenses are supposed to give notice of what the defendant will rely on. The bare statement like failure to state a claim tells the plaintiff nothing about the actual issue. Because of that, we need to strike it in the court that we're in. When presented as a standalone defense without factual support, it frequently fails to satisfy the requirements imposed on affirmative defenses and may therefore be considered redundant, conclusory, or illegally sufficient. Now, I want to share with you guys the document that we made. Now, if you guys are interested in this document, give me a call. There's two set of documents. One is we're asking them for a more defined statement and then we're jamming them up with the thing. Now I'm going to share with you guys here what the document looked like when we got done. And you can see right there the plaintiff's opposition to the defendant's Rule 12B motion to dismiss. This motion relies heavily on the plaintiff's failure to state a claim and relief was granted. Yet the phrase does not constitute a factual defense, nor does it introduce any new facts. So you can see this is, it's nice and short and very to the point. Right to the point. And for those reasons, the motion to dismiss should be denied. And certificate of service. Now, we came in with a demand for a more definitive statement pursuant to Rule 12E, just to just to make sure we understand what they're talking about. And this just chops up their crap a little more. And it outlines right there along the specific allegations that their demand for relief, and then we got to move that down to its own page. So that's what that looked like real quick. So this is coming up pretty soon. So we're get on out of here and get some more things done. I'll see you guys in the live stream in a little while. Thank you for the value of sharing your time. Mm. Yeah, 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 Okay, we getting that audio thing going on. We was doing good. I think we had my internet went out or something because it like froze for a second, and I think after that it was out to lunch. So I'm thinking you guys can all hear me now and everything is good. Okay. So before we get to talk about what I was going to talk about, because I haven't forgot about that, I just wanted to talk about the two things. Well, there's one more, but I didn't want to drag it on too long. I'll save the next one. Excuse me. I'll save the next one for the next time. Okay, but the subrogation situation is badass, and it's really hard for people to grasp or understand because 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 people have a hard time. People don't update. Okay, they don't update their computer database brain things in their brain that cause them to think about the way they think about things or whatever. Think about it. Most of us, well, not me, because I read the book, Think Again by Adam Grant. I read the book, and it teaches you how to rethink what you used to thought you thought you knew. You know what I'm saying? Because in order, it's really hard to roll without limitations if you don't have new computer banks looking at the real stuff, because the stuff that you learned a long time ago was trash. I'm just going to say it was trash. Everything that you learned everything that we learned about the legal system growing up was trash, lies, indoctrinated to us by the same people that's stealing our stuff. I think I got one of these, so I'm thinking, it's making me an expert. Okay, but I got some asshole people that okay, so I'm gonna throw some on. I got one of these. And I'm saying it's making me an expert because I got one of these and I ain't never been convicted of anything, nor have I took the deal to kiss their ass. Now, anybody coming to the table saying they've never been convicted, better throw that other side, that other little part on there, because if they don't, then they did. I'm just saying. So, the real-time feedback, the stuff that I learned along the way, I had to go back for, a forced medication order because they sent me back because I wouldn't take the deal and throw my wife at the time. I'm not married now, but to throw Carrie under the bus, like I would like I would have. These people ain't got no sense. Okay, so this subrogation thing is so badass. And I'm gonna tell you why. It can be used for car loans. It can be, I haven't got around to do that, but I'm working on it. If it was structured when I got it was structured around, challenging the fact that you're not a U.S. citizen. And that's good. It was working, but they're still trying to, But I kind of like to just punch them right in the mouth with the most important thing they don't want anybody to know. And it's not whether or not you're a U.S. citizen. I mean, but that's working for her up until this point. Okay. I like punching them in the mouth with stuff they don't want people to know. Okay, so this subrogation situation, you put yourself in. Okay, so notice number one, a notice in a judicial court carries more weight, carries the weight, way more than anything in administrative bullshit. I'm just saying. People ask me, "Oh, can I go to jail for doing that?" I don't. If they was going to take you to jail for doing that, I think my ass would already be there for selling it to you. Now they are grumpy and they've been following around. Bring it. All right, because y'all ran my ass out of fear. I don't have any more fear, you know? And maybe it's because I'm getting old. I don't know. I know when I was young, I was taught not to walk in the parking lot in front of old people because they just run your ass over, pretend they don't see you. And then, okay, no, I never had, I worked that last part in there, sorry. But the first part was true. Maybe that's where I'm at. Maybe I don't give a shit because I've already been through the worst they could do to me, period. You know, it's kind of when you can't protect your family or anybody, yourself. It may, I don't know, it made me a little weird. And then now I may have gotten just a little out of control. Okay, sorry. Okay, so what I'm going to tell you guys is, you know, people call me coach. How many have you won? Well, you know what? I ain't even got time to hear that shit or even, you know, ascertain it. I don't even want to. You ask me that shit, bang, I'm going to hang up on your ass. I don't give a shit. I'm going to hang up, but I understand that this program's not for everybody. I understand that. I understand that this program is for the people who are willing to step up and do whatever it takes. Oh, coach, can you go to jail? I don't know, can you? If they think you can, I'm sure they'll tell you that shit when you go run down there and ask them because you trust them more than you trust what we're doing on here. I think. I don't know. You know, the ring is only so big that we're in. Okay. And there ain't no second team. Okay. My dad was a Marine. And then he was in the Army later. Okay. But we'll talk about the Marine part. They don't take no hostages. Go ask them. You go ask a Marine, do they take hostages? And the first thing they're going to tell you is, you want to feed them your rations? Oh, hell no. I'm feeding none of my food. Okay, sorry. I got a little carried away. I tell people to go do your damn homework. Okay, I learned about this subrogation thing working for Coach K, and they were using them, but they didn't mention what it was. They didn't provide the document, and you know. So I'm mentioning, dude, what's this? You know, I need to see that. You know, what's it called? So she told me what it's called. Damn. By the time she sent it to me, I already had my eyes, you know, because I'm like, I don't know whatever it's called, but I think with the no that I got in my head, I think I can step that puppy dog up and make them not want to talk about it. Not only not want to talk about it. So this is so smooth because now you just put yourself in the lender position and you can sell the accounting and order them to deliver your deed to your house or to wherever the hell you want it. And in order for them to trump you or not do, then they have to prove that you should not be in the lender's seat. And they can't. They can't prove it. They don't have all their documents. The whole thing started in the sewer, in the cesspool. It did. It started in the cesspool. Now I know. Well, wait, I sat down to sign. Okay, no. Who sat down next to who from the bank sat down next to you to sign? Nobody. There was there was somebody that signed it after you left the table when they turned it into illegal security and then made a copy of it to send your ass to make you think that you had the lien. I did that, made a copy of that security, and try to, oh no, maybe knocking on the door real soon. That's how that they didn't, and they can't prove, okay, coach, I know what you're saying. Okay, coach, but they're just gonna ignore. Well, that's fine. Anytime the judge objects, throws your stuff out or whatever. We had the workshop a little while back, wasn't a whole bunch of people in it, but there was a few. And then the objection package that we have on the website is still marked down to $140 or $49, something. Those are the two documents that you use against any judge's decision. Any decision. Because they're in a minute, oh, coach, it fit my case. Oh, hell no, get the hell out of my face. Okay, sorry. Because we ain't talking about your case. Everybody's stuff is the same over here, or you just need to go throw your own shit in the yard. I'm just saying. Everybody's stuff is the same because here we're addressing the reason why they're able to screw you over so easy. Not what they did. I want to talk about what they did, coach, because they took my stuff. I want to charge them for copy paper, and I want to charge them for this and that. I need to stop the sale. You need to stop the entire foreclosure illegal process started with the violation of your due process at the gate. A long ass time ago when you sat down to sign that shit. They all knew what they were going to do. I mean, I wasn't there. I wasn't there, but they all knew, and they all made bank, and they still making bank. Until people started learning how to, do a different program. Okay, so people want to know, okay, so am I going to jail? Well, I've had people ask me that. Okay, so, okay, so the last lady asked me that. I told her, I don't know. I don't know what the hell you've been doing. She got mad. Okay, so go do your own damn research. Okay, I learned what the word subrogation. I just need to know how to spell it. Okay, but see, here's the thing. You can go do your own research, and if you only look at the first page, and don't go. And don't go and do your own research. Then you're not going to know. You're just going to be listening to what other people have to say. Or you're going to be asking the coach a bunch of stuff that he's not going to, this illegal says legal school. Okay, so I'm not trying to answer questions for you fast so you can hurry up and block the sale, so you can hurry up, whatever. Now, if you're in the eviction process, then we have a protocol for that, but we still ain't trying to hurry And you only need to file one document and their stuff is jacked up. Okay. We have instructional video in the instructional video playlist, the updated instructional videos are in the instructional video playlist. But you know what? We don't have to use all of that stuff in the package anymore. The most important video that y'all need to be watching is the counterclaim. The counterclaim video. Now, I'm not talking about the short ones that are a minute long. Those shorts are what we use to advertise in because they're jacking us up and not showing us stuff like they should. So each one of those short videos has a link into the product page. Now, if you're here for education, then you need to look for the videos that are longer than 3 or 4, that are longer than a couple of minutes, is what my suggestion would be. So you get everything in one sit down and not a little parts at a time. So that's how you want to do that. Now, what we've been doing is holding these people, and they're tricking us, making us think that they have us in a judicial court. And we're not. We're not in a judicial court, but you think you are. You think you're in a court that's can align with the Constitution, and you think that you have rights, and you think the judge is going to be fair. And you know what? The part that kicks my ass is the people that know the judge is not going to be fair because the judge has not been fair any time throughout their damn life, but they're still willing to go there. Oh, but I got to win. No. What we do is stop the court process. Okay? That's it. Stop the court process. In state courts, bullshit in the first place. Statutes and codes are not connected to the Constitution. They operate off of the local rules they make up. And they don't make those rules up for them. They make y'all ass follow them. Tell me if I'm click the bell down there and subscribe and ring some shit. Tell me if I got, I don't think I have this wrong. I think I got this right. Y'all can help me out. Okay, so easier ways to go about getting the shit done, easier ways to stop them. So now, if you go in with a notice, you're putting you're placing this notice in the public record where the deeds are. And you're giving them 10 days to, whatever days to prove that you shouldn't be there, or they need to deliver your deed and settle the county and deliver your deed and do all of that. Now, if you don't, because John Coach, they ain't gonna, then that's fine. Y'all know this ain't my first day rodeo. Okay, road. This ain't the first one. So what I'm gonna tell you right here, okay, is what you need to stop any judge in anywhere around here that I've seen that you're going to be in front of. Okay, the judge is not going to provide a finding of facts and the conclusions of law. They don't. So if they don't do that, then it just violated you in their administrative court, violated your due process. Oh, now everybody's stuff is the same. If you slide all that other shit out of the way, everybody's stuff is the same, and you don't have to be talking about my case or my case situation or whatever. I mean, unless you want to talk about the stuff that started in the middle of the cesspool, or you want to talk about the stuff that started at the gate, back over here. The stuff they don't want people to know about. They don't give a shit about your happy ass. And y'all happy asses, because there's more than one here. They're worried about everybody else finding out. And I'll tell you right now, you roll right with the stuff you get over here, judge ain't signing that shit. They ain't going to have it in the court. They're not going to have it in the court. And what they're going to do is the other side is going to send you a letter. When you get them burned on with the RICO stuff and block the foreclosure situation or any other stuff that you got, they're going to send you a letter. The attorneys are going to send you a letter. and they're going to tell you that your filing was deficient and it didn't have blah, 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 and you need to correct that shit in this certain amount of time. Oh, how many of y'all got that? Okay. In my head, what that means is that in that certain amount of time that's written down on the paper, the judge is going to throw all of that shit out. So the attorney has got to get your ass to comply before that date. Oh, coach, but how you know is bullshit. Well, why is it not in the case? Why is it not a motion in the court in the case? Bam. How I know is because I've done this a whole bunch of times. Yeah, that's the other way how I know. They'll send you the letter and try to get you to respond to the letter and all of that shit. Okay, and then and then once you get to jumping through hoops, they just hoop your ass right out the back door. My new coach is trying to find the show. Actually, I got two Coach K, so we're gonna call one Coach K, and then we're gonna call this new coach Dr. K. So Dr. K is trying to find the show. Okay, so everybody's like, well, I don't know if I can use a notice or whatever. Okay, so when you come with the notice of subrogation, move your ass in the lender's position. Okay, and then you force them to the fire that I got in and forces them to verify their accounting like they're supposed to do in the first place. I have in there, and they can't. They ain't even. I didn't have to put the actual documents in there. We just kind of referenced them in case they can figure out some kind of way. Then we're going to bring you out. So this package comes with coaching because we ain't done with it. Well, how many had you want? Okay, you know what? You can go sit your ass down. So how many hours have you spent doing the research before you came to get in my face on something that I'm selling on my shit, and I got just all and then I got the police following me around. These people would bother me, and we got the lawsuit filed, and we're going to talk about that in the next video because I want to talk about something else right now. But we got the lawsuit filed for the Kopecky shit that happened in 2023. And for Officer Delbert arrested me for no reason, whatever. We got that lawsuit filed in. Well, it was already filed in 2023, and I let it sit there because I wanted to. I didn't serve the parties, and then I had to go to Arizona and help my kid. Okay, so and then I want to see if they're going to try to give me some shit because I came in with a supplemental pleading and added fraudulent concealment to it, and I didn't add the RICO yet because I think I'm slapping them around enough, but I did reduce it from $5 million to $500,000 because Papa needs some new shoes and shit. So that was my offer. Okay, but we ain't done filing some stuff. Okay, because I got this one right here too. I'm just gonna let it sit right there so they can all see it. Cause I know them assholes are watching. Because when I filed the first one, boy, they backed off. And they was way back. Now y'all keep on following me. Y'all just pull your ass right on up and follow me like y'all been doing. Cut in front of me and try to cut me off and do all stupid shit. I record it all anyway, so y'all just come on. But this is for the Fed people and issues that with the the psych sending me back for the forced medication. It's been a long time, starting in 2005, 2005. And yeah, and the coach is right here, and we ain't even done. We got this puppy dog right here sitting in federal court. You can see the file stamping right there. Move it over. Yep. And then I had to leave, and then when I left to go to Arizona, and then I'm about to get divorced. So I really trust. So I just left it sitting there. And no, we're gonna get to this next. This is my friend. This is my foster kid's divorce case that we got dismissed. Case dismissed. Bam. Look at them fingernails. Ain't they hot? Oh, that's the wrong one. You can go to my YouTube channel and pull it up. Look up the case dismissed, marriage dissolution. Yeah, case dismissed. And we haven't even served them. We filed this, and the shit got dismissed. They went and parked their ass, and they told X, the BX. I'm trying to say anybody. Yeah, that she had to have answer to her own stuff. I ain't never seen nothing like that. That was pretty. Yeah, get dismissed, and but we're in a hurry for this because this is. Right now we just having some fun over here because they want to follow me around. So I'm gonna put in the next live stream that we'll have. Hell, we'll have it tomorrow. We're gonna have it tomorrow. I'm gonna have a side where I can open up the document that I filed against their ass, and I'm just gonna scroll down and let you see the whole thing. We're gonna have the trial for their ass. Oh, how does that sound? Huh. Have you ever had to have a trial for they asses? Put their ass on trial right here where the public can see, because the public can't see what's going on over there. Because they won't let y'all ass in the courtroom. Okay, wait a minute. Let me back that up. If y'all are here, going in the courtroom ain't going to help you nothing. Going in the courtroom ain't gonna help you now. Now, if the city of Lawrence, Kansas is watching, y'all need to understand that I dropped that lawsuit down from $500 million, and you can pull it up and look at the original one that was filed in 2023. I dropped it down from $500 million to $500,000. That was my check down negotiation situation. Okay, so. Y'all need to make sure you remember that. And just to let you know, the reason, and I had to bounce this shit off Lily's head, okay, because she wasn't going to just let me she called it leaving shit on the table. She talks like my grandmother, okay. Okay, I mean, it's like, all right, so just hang on, okay. I have a lot of friends that work for the city, okay? And I was really concerned, so I dropped it down from $500 million to $500,000 because I was concerned about the city's resources. I really was. More specifically, I'm sorry, I'm supposed to be serious. More specifically, I was concerned with the city's ability to, if their finances got too low, they wouldn't be able to buy toilet paper for the employees that still work there. They wouldn't have any toilet paper for any of the. I get what? That's Lily's over there laughing, and she thinks that that could be a serious situation. If you work for the city, we could talk about toilet paper Sorry. Okay, sorry. We're not going to talk about the toilet paper anymore, okay? Because it's you. Okay, sorry. Okay, come on, coach. You got this, okay? Okay, so, you look it up. I made the document from looking it up and learn out. Now, I was talking to a person that I was coaching, and I asked that person, I said, look, I want you to go and look up in the subrogation and see how, learn everything you can learn about it. And I wanted to talk to him later. And that person, well, no, coach, if you just give me your paperwork, I'll learn exactly. Well, you know what? It sounds like you want to coach your damn self. That's what I'm thinking. You need to have a foundation before you learn anything. Because you can learn everything that I have in that paper, but if you don't understand the other ways that they used it or they can use it, then you're not going to know how to keep the back door shut. That's how I see it. So those people that don't listen and go do what I said, they end up, for this person, I was going to help them do that, but we didn't now because they didn't do what I said. If you did what I said, then when we talk again, then I would pick your brain or have you stomp my brain. No, I'll call it picking your brain to see if you understand. And this is not that hard. It's not. Okay, so people say, "Oh, well, here's the subrogation, equity subrogation." Here's, one person said, insurance. Insurance is the only thing, Well, I read that. I read there's insurance, and I read there's what I read. No, so I went back more than a couple of pages, though. Okay, but you know what? If you're here, okay, and you're rolling without limitations, I don't give a shit what it's used for. If it's used for one thing, we're going to figure out how to twist that shit into what we need. That's how, Okay, now you jam them up with the notice, put yourself in the position. The notice is placed on the public record, so you just jumped ahead of that. That's slicker than the fraudulent. That's slicker than fraudulent. The notice of fraudulent conveyance, and the notice of, because I came up with those, but we wasn't demanding the deed be delivered, and we weren't. We were putting ourselves in line behind the lender, but not anymore. Not anymore. Now, if they want to ignore it, then there's a lawsuit in the package to sue them for, 2 documents. That's what we need to address any judge's decision against you. And now you're suing them. Oh, how's that line up in your head? Now you're suing them because they ignored your judicial notice, or because I have a lawsuit for that whole package. No one's even looked at it. Now you're suing them because they ignored your judicial notice. Now you're suing them, and I'm going to put it this way. I hope y'all guys get it. Now you're suing them. Now you're suing them for violating your due process. Now you're suing them and making them prove that they are the lender. Now you're suing them for violating your due process by ignoring the fact that you challenged them. You're suing, now you're holding their ass to the fire for judicial court rules where the Constitution is aligned. Mm. Mm. Everybody's stuck looking at it from the other side over there on the conventional side. Oh, I might go to jail. Oh, this, oh, dude, a notice has more freaking power than any of that shit. And just the way it's structured, you're letting the court know administrative facts, undisputed administrative facts. Now, it could be to protect the court. I mean, maybe you already got enough to sue their ass, and you don't want to sue anymore because I do this to myself. You don't want to sue them anymore and take any more of their money, okay? Because they're going to jack with you again, and they need to have some money for the next time. Oh, okay. So I'm a freak. That's all right. And I'm a good coach. Do your own research. If you did your own research on the word, I'm not talking about the word. If you did your own research on the word, okay, then now you see, it can be used for insurance. So how could it not be used for any damn thing else? Oh, this is like a whole nuclear class kick ass. I'm serious. I don't think people understand, because if they did, that shit is marked down to $600. It was $1,700 package because it came about from me doing a custom job, and I charged $1,700 for me to take the case and do the shit and send the shit to them, and then you have to take it over and whatever. $1,700. It's marked down $600. I got 2 people that are about to use it right now, but I'd like to have 5 or 10 people before they catch up with me. Bring that shit. I don't care. I ain't scared of y'all ass. Y'all, when y'all decide y'all want to jack with me, just throw me the cuffs. Okay, y'all ain't got to run up on me and shit. I'm too old. Y'all ain't whipping my ass. Just throw me the cuffs. I'll put them on, but y'all ass ain't coming in my house. Okay, because we already, I ain't opening the door for y'all ass unless y'all show with that rammer thing, that I seen on Cops. I don't think I pissed off that many people. I don't know, but no, but y'all have been ran my new front door either, because y'all ran my new front door. We're gonna have another situation. It'll be after I get out, but there's still, what this situation I'm addressing them right now started in 2005. Oh wait, it started before that with them harassing my carry at the business. So we didn't want to count down the years, but I'll tell you right now, I don't have that many more years to go forward. And I got a new friend. We need to go sit down and chill. I ain't got time to be doing all this stuff. So it's time for me to start relaxing, but not yet. Not yet, because I got this, and then I got this, and then I got the other thing that's already stuck in some people's faces, and then I got this. They're gonna be real mad about that. Oh wait, let me see if I can get it now. Yeah, that's there it is. The 3949A form. And I'm thinking we need to attach one of these with as an exhibit with your judicial notice. Because I already know that the court and northern attorneys have done what they are supposed to do with according to the counting and all of that stuff when they steal people's property and stuff. They don't do the stuff they're supposed to be doing, and they don't. But the reason we're going after this is the Judge Catherine Thesis. the judge that was in my foster kid's mess that dragged that shit on for, and Besco LLC is her is her company, and her company owns these. Her company owns some property up the street from the courthouse, and we included it in our federal filing here. Her stuff, and we included Besco right there, and so and the reason why we got this is because it said on the internet that that property that the judge owns had 39 residential people. Like, residential? That shit is commercial. Used to be a mortuary and shit. What are they talking about? I went over there. There's 39. Well, I didn't count them all because 39 law offices up in there. But she has it listed, or she had it listed at the time anyway, on the internet as residential. So I went over there. We did a live stream from there on a Sunday. And I showed everything in the background. I don't know how this could be showing on the internet as residential, and I showed the document. It showed it was listed as residential. I don't understand. So I'm just gonna report her ass to the my foster kid, my ex-foster kid. Okay. I think the cat's out of the bag now, ain't it? Yeah, we reporting her ass to the IRS because I don't know. I don't understand why there would be discrepancy in what the property is, whatever. I'm why it was not showing commercial. I'm just wondering if she's getting some kind of a tax incentive or something for it being residential, or she wants to pay more for it being residential, right? I don't know. But I think the IRS should check it out. And we were in federal court on that. And it was real funny how that worked out, because when we chatted them up with that, they first they brought these 3 people in from the Attorney General's office, the Assistant Attorney Generals, and then they created a whole docket with a bunch of fake shit. It was so funny. Okay, so they didn't realize that we already have been getting copies of everything on the docket sheet when we've been going down there 3 or 4 times. And then when these new people came in, all of a sudden, there's all this stuff. And the lady told my friend that he probably would want to get a certified copy. I didn't even know you could do that. Whatever. So, yeah, we do that now. And he got a certified copy of the docket sheet. And none of the stuff that we had already received that was on the docket sheet was on that certified copy of the docket sheet. Yeah, that's the one we got filed in federal court. That's the one we got filed in federal court. And okay, so to break that one down, my foster kid, he used my notice of dissolution package, and then they jacked with him 4.5 months later and tried to force him into the divorce situation, and then he let me do whatever I wanted, and I told him that they're going to be really mad at some point in time, and he said, "Dad, I've been in jail before." I was like, "Oh, Lord have mercy, dude, you need to keep that shit on the down." I said, "Dad, I've been in jail before." I'm like, "Dude, you ain't got to worry about it, because if you end up in jail because of what we're doing over here, my ass is going to be right next to you, or you're going to hear me in the cell screaming over there because they're still beating my ass." No, there won't be no ass beating. Okay, there might be some screaming, but They can come beat my ass if they want to. No, it ain't the first time that's happened. It's been a long time, though. Don't get me wrong. Anyway, so if you can use it for insurance, why couldn't you not use it for any damn thing else? See, people put limitations on themselves, and then you know. Okay, so I'm like, if they're going to tell me that I can't use it, they're going to kick my ass in court. I ain't going with this other bullshit, whatever. Y'all just, and I ain't talking about how the judge tell me. At any time, because eventually that's where it's going to go, then I already know I can do a supplemental pleading, which is how we make adjustments to the situation without worrying about leave of court and all that stupid shit. I do a supplemental plea and add the judge right to it. Bam! The judges violate your due process. The whole situation in administrative court, even on the federal level. Well, how do you do? Well, if you do your shit right, when you get to the federal level, well, they'll see the ass whooping that you gave them, that you're giving them, because they'll be calling them, trying to get them to stall and do all this shit to help them. They'll see that. And then they'll have to make the determination if your ass is going to get the letter. Remember? We talked about the letter. That's how, when they get in the ass whooped, they try to move it out of court. And then we got this letter. The letter says your shit sucked that you filed in court, and you need to take that shit out and kiss the attorney's butt or something. I don't know. I can never finish reading the letter, because I already know that that's the deadline that the judge gave them to get that shit out of their court. There you go. That's what I got in my head. Thank you, Rosso. Now, that's the premium foreclosure defense package that we got going on. Yeah, we had the real-time feedback. That's why what we do is weird. But people doing it are still in the house and they happy. Yeah, I need to get Lily in there. She's sleeping. She could have done a better job than I did tonight with the audio. Yeah, but that's all right, because we learning and we're doing it all on our own. And I forgot about this. I wanted to go ahead and I'll go ahead and promote, I always promote my friend Carrie Neighbors' book that she wrote. It's just a little something about the journey that we went through, and it's a bestseller on Amazon. And I was hoping that maybe she would write more books. It's a little bit about just a kind of a quick overview about what we went through to turn us into the people that we are today. And so I always, throw a plug in there for my family when they're jamming on some stuff. And then this right here is a book that my son, Alexander J. Neighbors, my son Alex wrote. Leveraged income. Do you use the power of debt to get ahead? So he has a class that he teaches people how to do. That's one of my good-looking kids. We got 3 or 4 good-looking kids. Yeah, it's book time. And, you guys, we got our first collaboration deal with Coursera. And I haven't closed it up and closed everything up yet, but we're getting it worked out. And I actually was talking to one of my friends today. I got new tires, and my friend that run the tire shop, she's taking one of the courses. I was like, well, sweet. That's pretty good. But this is the other book here that I was talking about. Think Again by Adam Grant. This book teaches you how to reprogram your mind with, maybe hold it still long enough, with updated computer databases based off of the now and not the yesteryear. And then there's one other book that this one here. Oh, how to communicate effectively with anyone, anywhere. This book here has, you can see it's got this book has helped me understand how to communicate effectively better with what we're doing or what we need to be doing or whatever. Now I still got some people that tell me I was harsh, or I had one person came to the table and started telling me that the state of Florida thinks that what we're teaching is sovereign citizen stuff, and they hate it and want to know if they go to jail. And when that whole conversation didn't go very well, so that conversation didn't go very well. But at some point in time, people are going to find out that what we're saying is true. Well, I think you should call me or contact me, or have you got something? And no, this is like we're throwing it out there. Have you invested in a package to get, we got a couple of eviction packages on there. I think the most important, one of the first videos I would watch is the counterclaim strategy. The counterclaim strategy teaches us how to stop the state court process, stop the process. And then, we have a new wrinkle in it where we have the procedural and the substantive due process documents to file after the judge rules, so we can stop any ruling. Basically, is how that's set up. And that whole package on my website's $149 or $40 or something like that. Object to the judges, but see, what you got to remember in eviction court is you're in a fake court, so you would object to the shit, and then you had to file your lawsuit either in state court, or I would just file in federal court if I was close to the eviction process, and then sue them all and serve them. That's how that. We have several videos, a whole bunch of videos on stopping the eviction process. Oh, thank you, Lil Ice Man. We've been working on this for a while now. Okay, guys, okay, Lily's behind me. I'm just checking. I don't hear her making any noise. So she's like, she ain't making no noise. I might have a situation. But I need to let her out, and I need to go get something to snack on. I need to call my friend. I will talk to you guys. I'll see y'all in the next live stream tomorrow. We'll be back tomorrow. We're going to talk about the arrest tomorrow. And I'm trying to find the video of the fight. I had the fight that I had that. Yeah, that was kind of ugly, but nobody got hurt. And that's and I learned that, if nobody's going to be getting hurt, you probably shouldn't be acting like that. I got skinned up pretty good. Okay, so I'm going to see if I can find that video of the actual fight and not just them hauling me off the jail. So, and I'm going to work this because we're going to have the trial. I should go down there and see if they'll give me the dash cam. I don't think they want to talk to me. I don't know. But they all got served on Monday. What is today? Yep, they got served yesterday. So they might be still in some meetings. I don't know. I emailed them a couple of times, though, because I know they like me. Oh, did I talk? We talked tonight, didn't we? I think we talked tonight. And I don't know. I mean, I don't know. People come here with a different name than I know when I'm coaching on the other side or when you're buying my stuff off the website, which are real names. I don't know who these people are, but I think we probably talked today. Oh, it's Kendrick. Okay. Well, yeah, I saw I got a call from you, Kendrick, but you just need to find me on WhatsApp and talk to me over there, man. Because we've been doing this call, and then there's like a long time period passed that I don't hear nothing from you, and I don't know what's going on. And that's really bad because if you're using the program and we're doing stuff, then we need to keep doing it, And if they do something, then you need to figure out why they did what they did and what you need to do to correct it, and then hit me up in on WhatsApp and was where the coaching goes. Coach, this is what they did. This is why I think they did it, and this is what I think we need to do to what I think I need to do to correct it. Now, when you come to a table like that, that gives me an idea of what you're thinking. I can coach you then. Okay. Now I understand what you understand, and I can say, hey, I don't call that hole in your hand. But when you come to the table and you can't tell me anything about what you think you need to be doing or whatever, and you've been here for a long ass time, I'm not just talking, then I'm talking to several people, because this is like a school. I'm not here to tell you what to do. I'm here to help you learn how to hold these people responsible for doing the same thing to everybody, violating your due process. Okay, I'm not here to help you stop the sale. And I say that because number one, you can stop the sale, but if you don't stop the whole process, you're still going to be in trouble down the road because they're going to stall. You stop the sale, but you ain't stopped the eviction process yet. And if you stop the eviction, you stop the whole thing, But what happens is, and I have this with somebody else that I talked to today. That's who I thought I was talking to. And she stayed in state court because she couldn't afford to go to federal court, or at the time and then eventually they went to federal court. Okay, but when you do that, then you're filing way more shit than what you got from me. Okay, and she had filed a notice, a demand for something, which is something that they file in their stuff. And when she filed that, it gave them jurisdiction again, and she never took it back. And this is why I tell people don't mix your stuff, my stuff, with what you were doing, because if you do, I can't help you. What most people was doing was a conventional bullshit, and it wasn't going to help you anyway. That's why you're here. I'm just saying. So if you stay in state court too long, or and some people get wrapped up in a pissing contest. My grandma used to call it a pissing contest with the judge. Some people get wrapped up in a pissing contest with the judge, and they don't realize that the judge is the one pissing on you. I'm just saying. They're plucking your nerve to get you to act like that. So they still, they got drama. They ain't moved forward. You ain't moved forward. They're still in charge. And then they send another hearing if y'all have to come back. I don't know. Somebody told me if I don't have this right, set another hearing for you to come back so they can try to get control of the shit again. So, if you did everything, then there's a step somewhere that got missed. Maybe there's disrespect on the state level because you stayed there too long talking shit and didn't get your happy ass over there in the first place, or I don't know. There's a step that was missed that's allowing the state court to still have. Now, one of the things that we learned is that when we use the counterclaim or the supplemental pleading, we have to serve them. So that's something that may be a step that's, and it's kind of funny because people are calling me, or if they're investing in premium package, then it comes with coaching. So they'll email me to find out, or message me, text me, "Hey, coach, are you busy? No, call me in an hour," or whatever, call me and we'll start talking. There's a step missed someplace. So in my head, there's a check down. Okay, did you add the lender? Because you add the lender, they're going to ignore your ass because they think you believe their bullshit. I don't give a shit what kind of fire you bring to the table. Okay, did you add the lender? Did you build? I mean, there's like, and then people start getting mad. I'm like, okay, just hang on a second here. I got 14 more seconds to talk to your ass, and then I got to move on to the next person that I already agreed to talk to. So if you understand the dilemma, if I get a little testy, or if I act like that our time, there's not value on this call for you and myself, then that's the situation. And at the end of the day, maybe it's your call that I missed because I spent too much time over here trying to explain to somebody how many wins, or trying to explain to somebody what you can get when you go watch the counterclaim strategy. Our whole thing hinges around the counterclaim strategy for stopping the state court process. And then we find we need to serve them the counterclaim to make it, because some states, whatever, and so they just like play dumb. So the counterclaim needs to be served. Supplemental pleading needs to be served. So we're learning, and and then we got the new subrogation situation. That package is still down to $600. I put it when we had the live stream last week, several days ago, and I'm just leaving it there because I'd like to have. I have 3 people using it. I'd like to have 8 or 9. I'd like to have 10 people using that puppy dog. So I'm going to leave it down the price, the price of, And I just tell you, do your own research. Okay, but here's the thing. The difference in the way I roll and the way some people roll is, they're like, oh, well, can I'm like, make them. I'm not going to sit around and ask Ken. I'm looking, can you be used over here? Well, I'm going to use the shit over here, and I'm going to make them tell me that, no, go sit your ass down. I'm going to make them tell me that. The people, these rules, and the hell with that shit. I don't see nobody using those rules and any of that shit to stop the fire that we're bringing to the table. I know. So I'm, their whole system is based off of fear and having everybody maxed out about shit. People are running around worrying about the sale of the house when you need to be worrying about the foreclosure, stopping the foreclosure process. People are running around worrying about that they need to be checking to see what you don't even how much time you got. You don't even know. Did you do any research to see how long the process? What's the next step? And all you got to stop is the next step. What's the next step? You can find out. But nobody does. They just freak out because of, stuff they thought in their head I don't know, wherever. I didn't know. I've asked nobody. What's to stop the next step? That's it. Yeah, why make it harder than that has it? If you stop the next step, that's like making their happy asses tap out. That's the way I like to look at it. Make them give up. Go sit down and shut the hell up. That's how I like to roll. I mean, I like to make them go sit down, shut the hell up. And any attorneys or anybody else out there that think that what we're doing right here, you ain't got to be like the other dumbass attorney and talking about the shit in the background. Shit, email me. I'll send you a link. You can just come right there to the top of the show up there, and you can say whatever you want. Just bring your fire. Bring your fire. If you bring the fire and shut my ass up, I give you some free shit. Bam, done. Because we about to learn. I don't have a problem being wrong if I'm wrong, because I'm about to learn. And we couldn't be doing what we're doing right now if I had the same attitude a lot of people have. Oh, you can't do that. Who told you that? Oh, they ain't telling me that. Well, they might be saying it, but they ain't getting a chance to say nothing in court because they gonna bring me the damn letter. All right, the letter. All right, I'm gonna let y'all go. Thank you guys for the very sharing your time. And Kendrick, you need to get over to the coaching thing over there. That's going to work out best. And then I don't know. You should know what is the situation now. I don't know, but we'll talk. Okay, guys, I got my dogs. What, you want to say bye to everybody? Come on. Come up here and say bye. Come on. Come on. She's trying to steal the show. She said, I just woke up, Poppy. You doing all right? ¿Quieres muerte? ¿Quieres muerte? Yeah, ¿quieres muerte? She wants to die. Okay, no, she won't. I think she wants to go outside. You want to go outside? Yes. Okay. She wants to go outside. What are you thinking? Okay, I know. Let me see. Okay, what? You can kiss. Okay. This is the Lily show now, and she's going to be attacking me here pretty soon. Did you just wake up? Okay. We got to go. She got to go. She got to go to the bathroom. See you guys later. See you in the next live stream.